to include language in regards to sexual harassment as well. And they also wanted specific language in regards to specific special classes included in that. So now there is a requirement for all districts to ensure that there is an annual training just along the same lines as DASA and some of those other mandated trainings that you have. So here I am. Make sure you signed in so that you do get credit for this training. And if there's someone not here, we work with the district in regards to that. So again, the main goal of the training is to make sure that you understand what is considered harassment in regards to the law and your district policy, to review some of the key elements that your policy has in place for you, to know how to report harassment, either whether you were someone that was the victim or something that you witnessed as an observer, and then some other external reporting procedures that are available to you if there was ever a concern of harassment. So as far as the definition is concerned for the law and within your policy, harassment is a form of discrimination. It's unlawful, okay? And the specific language includes those protected classes that I just kind of briefly spoke about. It's harassment on the basis of sex, sexual orientation, self-identified or perceived sex, gender expression, gender identity, and the status of being transgender. So those were specific language that was required by the law for districts to ensure that they had within their district policies. It's any unwelcomed conduct that's either sexual in nature or directed at an individual because of that individual's sex or perceived sex. It is conduct that has the purpose or effect of interfering with an individual's work performance or creating an environment that might be intimidating or unwelcomed for any individual within the district. It can be either explicit or implicit, and it could also be a condition of employment. Okay, so a lot of what we are talking about is perception. Even if you don't perceive something as being harassment or kind of crossing the line, if someone else is perceiving that as crossing the line, they have every right to have their perception and their opinion of it. Okay, so it's again being mindful of what your interaction is with your colleagues or anyone that's involved within the district. It could also include submission or rejection of conduct that then has an effect on employment decisions. Okay, and we'll talk a little bit about that too. A lot of this also centers around hostile environment, and I already can sense just from the interaction this morning that this district does not feel like there is that hostile environment. It definitely feels like a welcoming environment. With this policy and the law, it would be any discriminatory displays that you might have within your workplace. So let's say you have a screensaver on your computer that someone finds offensive. That could constitute something within your policy or be governed under your policy or under the law. It's also hostile actions that could be taken against an individual because of that individual's sex or any of those protected classes that we talked about on that first slide. This, I'm a very visual learner, so this just kind of breaks down the different types of harassment that could be covered within your, or that are covered under your policy or under the law. It can be those physical acts, which obviously are a little bit more concrete: touching, pinching, kissing, patting, hugging, grabbing, brushing against anyone that's associated with the district or with you in an employment nature. It could also include altered work environments, okay? And that's where we talked about if you had a screensaver and you're sharing an office space with a colleague that they find offensive, that could create an intimidating environment for that individual, and they could report it if they felt that they were feeling uncomfortable. We talked about computers, but also cell phones, so any text messages that might be shared, any emails that might be shared that might be offensive, any jokes, gestures, those are things that, again, to be mindful of because individuals could have different perceptions of what their feeling is in regards to it. Bullying, yelling, name calling, again, those are pretty concrete examples. And then any sabotaging of workstations, okay? So like leaving, maybe you're thinking it's a joke or something and you're leaving some sort of a display or some sort of paper or some sort of joke on someone's desk, or sending it to them, leaving it in the break room or in the faculty room, okay? All those types of things, again, it's about perceptions of other individuals. So just be mindful of interactions. It doesn't mean that you can't continue to interact with your colleagues and communicate with them, but just be mindful of what might cross the line for someone. Quid pro quo sexual harassment occurs when a person in authority trades or tries to trade benefits for sexual favor. So it's usually with somebody that's in an authority figure or a supervisory role, okay? And has the ability to be either to grant or withhold job benefits. So when we break it down into your policy and what is covered with definitions of who could be a target, it's anyone that is unpaid or paid within your district or has any interaction with your district would be covered under the policy. So that would be any consultants that come in, vendors that come in, any trainers that come in, anyone that's delivering information, whether volunteers that come in, anyone that is associated with your district, paid or unpaid, is covered under the policy and under the law. And the same thing goes for the perpetrator. It can be anyone that you have interactions with because you are a member of the district. Okay, so anyone that comes in to do a vendor or a training or consultant, or your colleagues or supervisors, anyone would be considered covered under the policy and under the law. Where it can occur, again, we talked a little bit about this last year, the concrete places within your district facilities, on your campuses, on your transportation. If you actually leave campus and you are with individuals, colleagues, supervisors, or whatnot, any outside locations could also be covered under your policy and under the law. Any work events, parties, anytime two colleagues go to a conference together, or maybe just go to a restaurant together, they could be covered under the policy and under the law. Where it gets a little bit more complicated is when you bring in social media and any sort of electronic devices, because texting, you can be anywhere. Email, you can be anywhere. Social media, you can be anywhere. So just be mindful of your interaction and what you're sending, okay? Sex stereotyping is when harassment occurs because a person does not conform to gender stereotypes. It can also be because someone's performing a job that usually is or previously was performed mostly by a person of a different sex, and that is called sexual discrimination. Okay, so making comments or judgments in regards to those types of settings, that could be sex stereotyping. So we have a new case study this year to try to change it up just a little bit. This one is about not taking no for an answer. So Jane's coworker Ralph has just been through a divorce. He drops comments on a few occasions that he is lonely and needs to find a new girlfriend. Jane and Ralph have been friendly in the past and have had lunch together in local restaurants on many occasions. Ralph asks Jane to go on a date with him, dinner and a movie, and Jane likes Ralph and agrees to go out with him. She enjoys her date with Ralph, but decides that a relationship is not a good idea. She thanks Ralph for a nice time, but explains that she does not want a relationship with him. Ralph waits 2 weeks and then starts pressuring Jane for more dates. She refuses, but Ralph does not stop. He keeps asking her to go out with him. I did not create this. This is actually from the state. Question 1. When Ralph first asked Jane for a date, this was sexual harassment. True or false? Excellent. Ralph's initial comments about looking for a girlfriend and asking Jane, a coworker, for a date are not sexual harassment. Even if Jane has turned Ralph down for the first date, Ralph had done nothing wrong by asking for a date and making occasional comments that are not sexually explicit about his personal life. Jane cannot complain of sexual harassment because she went out on a date with Ralph. Got it. Being friendly and going on a date or even having a relationship with a coworker does not mean that that coworker has the right to behave as Ralph did towards Jane. She has to continue working with Ralph, and he must respect her wishes not to engage in that behavior and not engage in behavior that has now become inappropriate for the workplace. Jane then complains to her supervisor, and the supervisor, as required, reports her complaint to the person designated by her employer to receive complaints, the compliance officer. Ralph is questioned about his behavior, and he apologizes. He is instructed by the designated person to stop. Ralph stops for a while, but then starts leaving little gifts for Jane on her desk with accompanying love notes. The love notes are not overtly offensive, but Ralph's behavior is starting to make Jane nervous, as she is afraid he might stalk her. Ralph's subsequent behavior with gifts and love notes is not sexual harassment because he has stopped asking Jane for dates as instructed. He is just being nice to Jane because he likes her. True or false? Jane should report Ralph's behavior because she was entitled to have effective assistance in getting Ralph to stop his inappropriate workplace behavior. Because he's returned to pestering Jane after being told to stop, he could be subject to serious disciplinary action for his behavior. So the coworker has told him to stop, the supervisor has told him to stop, he needs to stop, otherwise there could be additional discipline actions that are occurring. Questions about that? Okay. So again, interactions and being friendly with coworkers is okay. It's when that line is crossed is when the policy would be covered or be enforced. So if you feel like you are harassed or you witness harassment, it's almost like being a mandated reporter at this time, where you are required to ensure that you tell a supervisor or tell one of the compliance officers. Jen Hall is the Title IX officer, but you also have your building principals or your administrative team or supervisors to make sure you go to address any concerns that you may have. Even if you don't think it constitutes harassment under the law or under the policy, maybe it's just unwelcomed behavior, please make sure your supervisors know, because we want to make sure everyone feels safe, everyone feels comfortable, everyone enjoys coming to work, and even if it's not to the level of harassment, it's important to make sure your supervisors are aware. You're encouraged to report the harassment in writing, but any verbal concerns are also welcome. This is just an example of the complaint form, the written complaint form, but as I said, you can also verbally bring a complaint to any of your supervisors as well. If you witness it or you just feel you've heard some things and you feel uncomfortable about things, please make sure that you go to a compliance officer or your administrator. It is unlawful for any employer to retaliate against you for reporting any harassment or assisting in any investigations. So if a report is made, whether it's harassment or not, at the point that it's actually reported, it is something that has to be addressed or investigated immediately. Okay, so the first thing that would happen is that there may be some initial actions that might have to happen during the investigation to ensure that everyone feels comfortable and everyone feels safe while things are being addressed and looked into. Any parts of the investigation will be kept confidential to the best extent possible. So if it has something to do with needing witnesses or needing to interview other individuals, that might need to happen, but the nature of the complaint would not be shared, and any personnel type of outcomes would not also be shared. We do ask that any employee that is asked to be a witness or asked to be interviewed, comply and cooperate with the investigation. That's it. That they comply and cooperate with the investigation. The compliance officer is the one that would take the report and conduct that immediate review and make sure that any interim actions that have to occur happen. There may be documents or emails or phone records that are asked of. Remember, any district items that you are given, computers, cell phones, anything along those lines, They are something that can be brought into an investigation or documents that can be looked at. Remember, they're district property, so be very mindful of what you're using those tools for. Interviews will also be conducted, and then the individual who complained and those that are accused would be notified of a final determination and any appropriate administrative action. Again, any personnel type of information, there are specific things that might not be able to be shared with you, but you would be given a final determination of whether or not it was harassment or not. We talked a little bit about retaliation, and as I said, any employee that engages in any of the protected activities, so they come forward with a complaint, they provide information, or they testify in regards to a complaint, those protected activities are covered under your policy and under the law from being retaliated against, okay? Any action that could alter an employee's terms and conditions because they engaged in those protected activities is prohibited, okay? So that would be any sudden changes of work schedule because you might have come forward with a complaint, a demotion because you were part of an interview for a complaint. Those things are prohibited under the retaliation component of your policy. That does not mean that supervisors and administrators can't continue to supervise. Performance-related concerns can still be addressed whether or not individuals were providing any information or doing any of those protected activities during an investigation. So if your supervisor has been speaking to you about attendance-related concerns throughout the course of a period of time, and then you were part of an investigation for a harassment complaint, and then they talk to you again about your attendance, that does not mean that it's retaliation. They're doing their job as supervisors. They're making sure that you're following your job description and your duties and your responsibilities. And so that's not retaliation. All employees are subject to all job responsibilities and policies, regardless of whether or not there was a concern of harassment or not. Some additional protections and remedies. I thought I was going to get it before this. Some additional protections and remedies outside of the district policy. So these are external options that you have. You can always file a complaint with the Division of Human Rights. That is, any complaints must be filed by the DHR anytime within 1 year of the actual harassment. You do not need to have an attorney to file, and there's more information on the website, the www.dhr.ny.gov. You also have the United States EEOC, Equal Opportunity Commission. This is a vehicle where any individual can file a complaint within 300 days from the alleged harassment. You do not need an attorney to file, but a complaint must be filed with the EEOC before you actually file in federal court. Okay, that's the one caveat. And there's more information on the EEOC website. The U.S. Department of Education, so more on the federal side, also enforces Title IX, okay? So there's more information about how to file a complaint through the OCR, the Office of Civil Rights, on that long website that you will have a link to through this presentation. The local protections that are available to you are obviously the local law enforcement. So anytime that you feel that there may have been anything that may have crossed the line in regards to breaking a law, please make sure you contact your county, city, or town to see what laws may exist and to report any concerns that you might have to the local police department. So in summary, we just want to make sure you know how to recognize harassment, and if you ever have questions or concerns about anything that might be happening, please address them with your supervisors or the compliance officer. Any harassment, because of the protected classes we talked about in that first slide, is prohibited. Any workplace harassment is discrimination, so we want to make sure that everyone feels safe and comfortable coming to work. As I said it multiple times, all harassment should be reported, And supervisors and managers have a special responsibility to ensure that that they report harassment and that they obviously follow through on any concerns or complaints that come to them. These are your two policies, and the second one is actually the regulation that follows the policy, and as we talked about, there's also a physical complaint form that you can also fill out. Questions?